Court calls the cases of the people versus Antonio Young, 3 cases.
Alex, then on behalf of Your Honor.
Me again, Judge Christina Costantino, appearing on behalf of Antonio Young in the case number ending in 1177.
Stephanie Cannon on behalf of Mr. Young in cases ending in 1381, 5188.
All right. And Young, can you state your name, please?
Antonio Young.
All right. And what are we doing?
Your Honor, an offer has been presented to me, and I have given that information to my client. He's asking for a brief adjournment so he.
This courtroom calendar may look routine at first glance, but don't be fooled. Today, we're watching the justice system in motion, where every adjournment, every plea discussion, and every bond continued decision can dramatically change someone's future. From global plea offers to restitution negotiations and preliminary exams, this docket quietly reveals how leverage, timing, and strategy shape real cases. Pay close attention, because the biggest consequences often come wrapped in the calmest courtroom moments.
Can consider that offer.
And Your Honor, if I can also put on the record, the offer was extended back in November. So at the next date, if he does not accept the offer, it will be closed and offer date.
Understood, Your Honor. That's what I said.
Just, all right. And what are we doing on yours, Ms. Constantine?
Your Honor, there's been a global offer that was extended.
Okay.
My matter will likely be resolved via that global offer, but it is pending resolution of Ms. Cannon's matter. So we would be asking to adjourn to tag along with her matter.
All right. You'll be able to get an answer by the 29th, or you want the 5th?
Absolutely, Your Honor. I mean, I understand that for sister.
I'll go to.
The 5th is better, so we will.
Oh, so you're doing something for somebody else?
I
Really,
am
Cannon?
a team player.
Yeah, okay. February 5th, 2026, 9 a.m. Bond will continue in all of these matters.
Thank you. Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. Cannon tried to be a nice person. Court calls the case, People versus Sabrina Wade.
Prosecuting attorney on behalf of the people.
Assistant Public Defender Jay Valentine on behalf of Ms. Wade. Ms. Wade, can you please state your name for the record?
Yes, Sabrina Wade.
Thank you.
Your Honor, we're just looking to set this for a preliminary examination. Discovery is complete to the best of my knowledge.
People have their witnesses available on the 20th?
No.
Preliminary examination in person, January 20th, 2026, 9 a.m. before Judge Freshour.
Okay, that's going to be here, okay? Okay,
Bond will continue. All right.
20th at 9 a.m.
Thank you, Ms. Wade.
Okay,
Okay.
January 20th, 9 a.m. Thank you, Your Honor.
Thank you. Court calls the case, People versus Benjamin Whitfield.
People.
Assistant Public Defender Jay Valentine on behalf of Mr. Whitfield is approaching. Mr. Whitfield, can you state your name for the record, please?
Benjamin Whitfield.
Thank you.
Your Honor, just seeking an adjournment for the time being. Some discovery to still go over.
This, you got additional discovery. All right. Probable cause conference, February 5th, 2026, 9 a.m. Bond continue. Thank you.
Thank you.
Court calls the case of the People versus really Roger Wharton.
Alex, then on behalf of.
And Stephanie Cannon on behalf of Mr. Wharton, who is approaching. Can you please state your name for the record?
Roger Wharton. Thank you.
Your Honor, we are asking that this be set for a preliminary exam.
So you want a preliminary exam?
Yes.
Discovery is complete.
Your Honor, there is a video, but we have been assured we're going to get it this week. So if they're aware of it, they said it's being sent over. So we are
Okay.
ready to move
Your
forward.
client understands that if for whatever reason that's not there, you're not going to get an adjournment.
He understands, Your Honor.
And Your Honor, we do have the video. It's just being sent by our office.
Got it. People have their witnesses available the 20th.
We'll do our best.
preliminary examination in person, January 20th, 2026, 9 a.m. That is before Judge Moore. Bond will continue.
Thank you so much, Your Honor.
Court calls the case of the people versus Tierra Williams.
People. Good afternoon, Assistant Public Defender Dottie Leib on behalf of Ms. Williams. Ms. Williams, can you please tell the court your name, ma'am?
Yeah, well,
Thank you.
And Your Honor, I do have a green sheet requesting an adjournment. And we do have a deal worked out. We're just waiting to get a restitution number from the people, which he's indicated me should be able to provide shortly.
January 29th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
This case, people versus Gabriel Wilson.
Alex Chaplowski for people.
Brian Mulling on behalf of Ms. Wilson, Your Honor.
Your name?
Gabrielle.
Judge, I'm asking for an adjournment so we can have some ongoing or additional plea discussions regarding this matter.
Okay. Matter will, probable cause will be adjourned February 5th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Thank you. Let's call the case of the people versus JaVale.
Assistant Public Defender Chelsea Vergils with them on behalf of JaVale Wilson. Please state your
Take
name.
your hands out of your.
JaVale Wilson.
All right.
May we briefly approach?
You may. All right, record to reflect, we've had a bench conference in this case. Understanding what needs to go on or needs to be looked at. I'll adjourn this to February 5th, 2026, 9 a.m. Okay,
Thank you, Your Honor.
bond will continue. Thank you. Court calls the case of the people versus Asil Al-Sahori.
Good afternoon. Jamil Kuja appearing on behalf of Asil Al-Samhouri, who's present on Zoom.
All right. Ma'am, can you state your name?
Asil Al-Samhouri.
Thank you. I have a plea form before me that indicates she's going to be pleading to an added count 2 of larceny by false pretenses, 200 to 1,000, the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. There is also the prosecutor and defense agree to a sentence agreement of HIDA. I'm also checking the sentencing judge waiver. She does understand I would not be the sentencing judge. Counsel.
Yes, Mr. Al-Samhouri, you understand that Judge Simpson would not be your sentencing judge. It would be transferred to another judge.
Yes.
Okay. All right.
Thank you, Your Honor.
So that's the court's full understanding of the agreement.
This is one of the most important moments in the entire docket, when the judge carefully explains the plea to larceny by false pretenses. She's not just reading legal language, she's locking in consequences. A misdemeanor may sound minor, but this carries up to a year in jail, thousands in fines, and restitution that can triple the amount taken. Notice how the judge confirms voluntariness, waiver of trial rights, and appeal rights. This is about closing the door to future challenges. Do you think defendants fully grasp what they're giving up in moments like this?
That's correct. All right. Mr. Kuja, is that correct, sir, from your understanding?
It is correct, Your Honor.
All right, very good. Ma'am, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you?
I do.
State your name again for the record, please.
Asil Al-Samhouri.
All right. Ma'am, it is this court's understanding that you are going to be pleading to the misdemeanor charge of larceny by false pretenses, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, I do.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, Judge.
All right. You understand that you're waiving or giving up all of the rights contained on that form, including the rights contained in paragraph 5, which are your trial rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Judge.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Judge.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
December 22nd, 2023, at the location of 1166 Ecorse Road, Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do that makes you think that you're guilty? Well, let me ask this. Did you present a check somewhere?
Yes.
Okay. And you knew at the time of presentation of that check that there was something defective in that check where you shouldn't have been receiving the proceeds?
Yes.
Okay. And did you receive any proceeds?
Yes.
All right. And the amount that you received, was that in excess of $200?
Yes.
All right. And just so that we're clear, that was $200 that you were not entitled to, correct?
Correct.
Legally or otherwise, correct?
Yes.
All right. So, ma'am, if I accept your plea, I have to advise you that if you commit misconduct as defined under the Michigan court rule between the time of my acceptance of your plea and the time of sentencing, that number one, you could not withdraw your plea. And secondly, the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, I do.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor, thank you.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be February 10th, 2026, 10 a.m. before Judge Washington. Bond will continue. All right. Thank
Your
you.
Honor.
Thank you, Your Honor.
Have a good day, bro.
Yes, sir. Good seeing you, Mr. Kuchar. Court calls case. People versus Miko Stewart.
Good afternoon, Your Honor. Bringing the cook for the people. Good afternoon, Your Honor. Yvonne Fairmont Keller, P 84328 appearing. Mr. Stewart, who was present to my right. State your full name. Stewart.
Thank you. And you're requesting an adjournment?
Yes, Your Honor. I've had the opportunity to make productive steps with the prosecution towards resolution. We just need a little bit more time to run into the goal line, so to speak, Judge.
Okay. Probable cause conference, February 5th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Thank you. Court calls case, People versus Kevin Jackson. Kevin Jackson.
Andrew Childers appearing on behalf of the people. Here. Mr. Jackson is in the hallway.
Good afternoon, Your Honor. J. Grant Miller, P 58658 on behalf of Mr. Jackson. Please state your name.
Kevin Jackson. Okay, what are we doing?
Your Honor, I have the discovery except for the body cams. We'd like to set it for an exam because the report
And if you don't
indicates,
get the body cams before I set it for exam, that's not going to be the basis for an adjournment.
I understand that the police report clearly says they didn't recover a weapon on the body cams. So I'm not sure that I need them.
Okay, I don't need to know all that. You want it set for exam?
Yes, please.
People have their witnesses available the 20th.
That's fine.
Preliminary examination in person. January 20th, 2026, 9 a.m. before judge. Fresh hour.
Thank you, Your Honor.
Thank you. Bond continued. Court calls case People versus George Capone.
Rob Down, Assistant Prosecuting Attorney on behalf of the people.
Mr. Pan's in the hallway. Could you ask George to come in, please? J. Grant Miller, P 58658 on behalf of Mr. Pan, who will be approaching momentarily.
Want the letter. You sealed that. Your name?
George. Your Honor, I've been in touch with the prosecution. I believe we have all the discovery and everything else, and we just need to set a date.
People have the witnesses available the 20th.
Right.
Preliminary examination in person, January 20th, 2026. 9 a.m. That is before Judge Moore.
Thank you, Your Honor.
Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Daryl Jarrell.
People.
Kyle on behalf of Mr. Jarrell.
Daryl.
How you doing, sir?
And
Waiving.
yes, Your Honor, the court should be in possession of a executed waiver form.
Sir, you're waiving your right to a preliminary examination in these matters? All right, you understand that that's a hearing where the people would have to show by probable cause that the offense alleged or the offenses alleged were committed and that you committed.
I do.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive the right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2.
Stand mute, waive formal reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
February 26th at 1:30 before Judge Slide.
February 26, 2026, 1:30 before Judge Slay. Bond will continue. Thank you.
Thank you, Judge.
So, yeah, I mean, I'll make time, but
I'm just.
do you have them?
Not yet.
Okay. Court does call the case, People versus Malcolm Hanks.
Noon, Judge Christopher Quinn appearing on behalf of Mr. Hanks.
Mr. Hanks? Oh, okay. Well,
Andrew Childers appearing on behalf of the people.
your name, sir?
Malcolm Hanks.
Thank you. All right, what are we doing?
Need another day, Judge. There's some, I think some video discovery that I need to obtain that I haven't received.
Video discovery. All right. January 29th.
Can I get the 5th, Judge? I know, I have a trial that week. The 5th would work better.
I'll give it to you, but you guys got to be ready to go when I say you need to be ready. February 5th, 2026.
Thank you, Judge.
9 a.m. Bond continue. Thank you, sir.
That's what I have to be. February 20th.
February 5th. Yes, sir.
Okay.
All right. Court calls the case of the People versus Tracy Reed.
Good afternoon, Your Honor, Raymond Cook, the people.
Christopher Quinn appearing on behalf of Ms. Reed.
Ms. Reed, you need to unmute state your name, and get someplace stable. Seriously. State your name.
I can tell you what we need to do, Judge.
I cannot. I can't hear you, ma'am.
I can confirm for the court that that's Tracy Reed, Judge.
Okay, fine. If she's gonna appear via Zoom, she needs to know how to work it. What are we doing?
I would like to set it for a PCC on the 5th as well, video discovery, Judge.
Probable cause conference. February 5th, 2026, 9 a.m. Because she doesn't know how to work Zoom, that proceeding will be in person. Bound continued.
Thank you, Judge. Have a good day.
Okay, so the people versus Nora Rita.
Andrew Childers, appearing on behalf of the people.
And good afternoon, Your Honor. Jessica Holland, P 86695 on behalf of Ms. Rita, who stands to my right. Please state your name for the court. Nora Rita.
Good. I could hear that. Go ahead. All right, what are we doing? You're seeking an adjournment?
Yes, Your Honor. We're asking for the 29th.
You're asking for what day?
The 29th, Your Honor.
She's so nice. I really should chew her out for asking for a day because I was going to set it for whatever I want. Press conference, January 29th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor. Happy New Year, Judge.
And to you.
Thank you.
Court calls the case, people versus Joseph Salazar.
Andrew Childers, appearing on behalf of the people.
You're muted, Mr. Nelson. Still muted. You're saying brilliant things. I just can't make them out.
There's the brilliant things, Your Honor.
There we go. Now we're going to hear the brilliance come through.
Okay.
State your appearance, sir.
Your Honor, Mitchell Nelson, P 22825, appearing on behalf of Joseph Salazar, who's also appearing via Zoom from Miami, Florida. Introduce yourself to the court, Mr. Salazar.
Joseph Salazar.
And Your Honor, we are asking for additional time.
Was the Miami, Florida thing just like white? It's like 30 degrees here. Did you do that just to like upset me or what?
I wish I was there too.
Okay. All right. What are we doing?
For a continuance, we're near a resolution that would not require Mr. Salazar to return to the state of Michigan, and I think about a month would be adequate.
I'm going to make him return just so that he probably doesn't know what cold feels like anymore. So
the case is very old, so it's been a long time.
Okay. All right. What I will do, probable cause. Well, February 5th, will that give you enough time?
Yes, thank you, Your Honor.
If you think? All right, February 5th. 2026 at 9 a.m. or as your invite indicates.
And thank you, Your Honor, for the courtesy for allowing me to do this via Zoom due to the family emergency.
Oh, not a problem, sir. All right. People who have practiced in the manner that you practice are always entitled to that courtesy as far as this court's concerned. All right. Thank you, sir. Have a good one.
Happy New Year.
And to you. Salazar, stay warm. Court calls case of people versus Nicholas Smith.
Good afternoon, Your Honor. Robin Kennedy. Nicholas Smith, who's present via Zoom. Mr. Smith, can you please state your name for the record?
Yes, Nicholas Smith.
Okay, there you are. Okay. And what are we doing on this today?
Your Honor, I do believe we have a resolution. The last time that we were here, we adjourned just to ensure that the documents made it to the court file to complete the plea.
Yeah. Were they sent in?
I had provided them to the prosecutor prior to the last hearing. I believe we were just waiting on their signatures.
Oh. I don't have any paperwork.
I'm not sure generally, Your Honor. I made complete form, sent it to the defense counsel and had them forwarded along.
To the court.
I don't have any emails from Ms. Kennedy about that. Not that, based on the notes on the file, I don't believe she's making any sort of misrepresentation that there is an agreement and that Mr. Smith has been admitted to an Ingham County district, the Ingham County sobriety court. That's all well and good, but we do need to make this form, so.
We don't have the forms all complete. All right, here's what, well, he's already been accepted and I don't really want to delay, but.
Do it quickly.
Well, it's been a long day. If I put it out 1 week, I usually don't like adjourning 1 week, but can we do it on the 15th and get everything in and then make sure it all happens?
I will be out of the country on the 15th, Your Honor, but in order to get it complete, I would have no problem having someone stand in for me just so that we can get the plea complete. I will make someone available and have them submit all of the Zoom documentation in my place.
She's going someplace warm. After that Miami comment, everybody appearing here is going someplace warm. I'm getting a little irritated. Bird, are you going someplace warm?
None of the time, so.
Okay, all right, because if you were, I'm coming off the bench at you. All right, here's what I'll do. Let's get that in there and I'll adjourn this out to January 15th, 2026, 9 a.m. or as your invite indicates, bond will continue. All right, and we'll
Thank
get
you,
the
Your
paperwork into
Honor.
me. We'll take care of it. Thank you.
Excellent. Thank you so
All
much.
right. Yep. Be safe on your journey, please.
Thank you, Your Honor. Have a great day.
Court calls the case, the People versus James Young.
Thank you, for the people, Your Honor.
Good afternoon, Your Honor. Barton Morris, appearing on behalf and hopefully with Mr. Young. Yeah, he's right there. We had just received some discovery this week. I have not had the opportunity to review it, and it might be voluminous, and I'm asking for likely a final probable cause conference.
All right, Mr. Young, can you state your name, please?
James Young.
All right.
And for the record, Your Honor, that is all correct. That should be the last piece of discovery in this matter. If Mr. Morris wants to come and view any of the images that are discussed in said discovery, we'll have to schedule an appointment with the U of M Police Department to do so.
Okay, so there may have to be. Let me do this. I'll adjourn then probable cause February 5th. Will that work for you, counsel?
Checking. Yes, Your Honor.
All right, February 5th, 2026, 9 a.m. or as your invite indicates. Bond will continue.
Thank you, Your Honor.
Thank you, sir.
Thank you.
Court calls the case, People versus Haley Garcia.
And good afternoon, Your Honor. Attorney Maxwell Dubin, P number 86012 on behalf of Ms. Garcia, who appears via Zoom with consent, Your Honor.
Your name, ma'am?
Haley Garcia.
All right. What are we doing today?
Your Honor, I've been talking with the prosecution. We are close to a resolution. I'm just going to ask for another brief adjournment on this one due to the fact there is immigration issues at hand. However, I do and I'm confident.
Okay, but I don't want to hear about that.
Okay.
I really don't want to hear about that, but you need more. You need more time.
Correct.
February 5th, 2025, 9 a.m. bond continued.
Thank you so much, Your Honor. I hope you and your staff have a.
Which
wonderful rest of your
prosecutor are
day.
you dealing with?
Myself.
So,
You are?
yes.
Then you can explain to council some things that I may not want to hear, and that if I hear them again, we are going to have a real problem.
Understood, Your Honor.
Thank you.
Understood, Your Honor.
Court calls the case, People versus Denicia Charles, I think.
Yes, Your Honor. If it please the Honorable Court, Brandon Bird on behalf of Denicia Charles. Ms. Charles, can you please state your full name for the record?
Denicia Janelle Charles.
Thank you. What are we doing?
We're setting this matter for exam on the RNO, and I believe the child abuse will be dismissed, Your Honor.
That is correct, Your Honor. I did inform me. We'll be dismissing count one.
Okay, so. Count one. Then discovery is complete then as to that charge.
As far as I know, Your Honor.
And would the people have their witnesses available the 20th? Okay. Preliminary examination will be set January 20th, 2026, 9 a.m. before Judge Fresh Hour.
This exchange is courtroom tension at its rawest. The judge makes it crystal clear mercy today does not mean leniency tomorrow. Despite extensive mitigation arguments, the court draws a hard line. Any future violation means immediate jail time. No excuses, no explanations. This isn't just discipline, it's a final warning. Judges rarely say, "I should put you in today," unless the margin for error is gone. Was this a fair balance between accountability and compassion, or did the defendant already exhaust that goodwill?
And that's only on count 2. Got it. All right, bond will continue. Thank you. Thank you. Court calls the case, People versus, is it Darius Johnson?
And yes, Your Honor, Brandon Bird on behalf of Darius Johnson for case, the case ending in 5312.
In the case ending in what? Oh, 5312. Gotcha.
Excuse me, Brian Rowley on behalf of Mr. Johnson in case ending in 1724, Judge.
Here you go. All right. And what are we doing? You're requesting an adjournment?
Yes, please, Judge, for additional plea discussions. Both, but.
Probable cause conference, I will adjourn to February 5th, 2026, 9 a.m. In both matters, bond will continue.
That was January 20.
No, I gave you February 5th.
February
You want the 29th? I mean, I can give that to you.
Oh, February 5th is all right.
Well, you're trying to cause me a problem, aren't you?
Sometimes my ears, you know.
All right, thank you. Bond will continue.
Can we address one issue of bond, Judge? Real quick?
Sure.
Hoping to travel to Texas. The
Why?
Dallas area for a family matter, from January 10th through the 18th.
January 10th through the 18th in Texas.
Correct.
What part?
Dallas.
Dallas? That's where them Cowboys are.
Yeah, but they're not playing football anymore.
I know, and I don't like it.
He doesn't either, John.
You don't?
Lions fan.
You're a Lions fan? Okay, that'll work. Maybe I'll let him go. Oh, you fill out a form for me. All right, I will, he can go to Texas. Those include your travel days, the 10th through the 18th? Yeah. All right, you can go to Texas, 10th through the 18th. Sure, all right. Thank you. I've already put them there. Off my back. Court calls case, people of the state of Michigan versus Kevin Jones.
And on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Kevin Jones. Mr. Jones, can you please state your full name for the record?
Kevin Jones.
I'd like to set this matter for exam, Your Honor.
For exam?
Please.
Right, your discovery is complete.
As far as I know, Your Honor.
People, other witnesses available the 20th.
We'll do our best, Joe.
Preliminary examination in person, January 20th, 2026, 9 a.m. before Judge Moore. Bond will continue. Thank you, sir.
All right.
Court calls the case, the people versus Anastasia Ricks.
Andrew Tool is appearing on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Anastasia Rakes. Ms. Rakes, can you please state your full name for the record?
Anastasia Rakes.
All right, first of all, Your Honor, we tried to take a plea last time and it didn't go over so well, but I did get a chance to go over the video with my client, go over the plea, and I believe she's ready to plea now. Now, I believe we have another matter that we have to discuss about the bond violation in which my client has a warrant. And whenever you want me.
She does. Let's deal with the bond violation. I may not be taking a plea today.
Gotcha. Okay. First of all, Your Honor, my client indicates to us that she wasn't drinking.
She what?
She wasn't drinking. And honestly, I don't say this about everybody, but I do believe my client at this point. First of all, the blood alcohol level was 0.04. It was 0.04. If my client would have been drinking, especially with the problem that she has, it would have been way over 0.04. It was only for that one day. If you notice that she went.
If she had been drinking, it would have been over that amount?
It would have been over that amount because my client doesn't know how to stop drinking. And she understands that she has a problem. That's just one thing. But if you notice that she went through Christmas, she went through New Year's, and I believe Thanksgiving, you had zeros all the way across the board. And if you do remember this case, my client's the one that actually said, I don't want the breathalyzer because the breathalyzer is too easy to cheat, and put herself on this alcohol tether to show the court that she couldn't that she wouldn't drink. She indicates to me that she is a clean. She's obsessed with cleaning, and it is possible that those chemicals got to her tether. But in all honesty, Your Honor, dealing with the facts of the situation that we got in front of us, we got somebody that asked to be on a stricter, to be on something stricter, to show the courts that she wasn't drink, to address her problem, even more, to make sure that she's not cheating the court. We got somebody that has dealt with alcoholism for a long time in life. And like I said, when she does drink, she drinks a lot. And she understands that. And she's looking for help. She's searching for help. She showed the court that she's searching for help. So when she does drink, she drinks a lot. And the fact of the matter is, that's why that 0.04 doesn't. I can understand when she told me that I'm not drinking. I'm not drinking. I wouldn't have put my kid in that situation. I'm all he has at this point. And she's been responsible. She showed her response. She showed she's been responsible. Like you told one of my clients, the most major drinking holiday days that then came with Thanksgiving, the day after Thanksgiving, New Year's Eve. She showed that it's been nothing in her system. So I do believe it was an honest mistake. And I do believe that my client can't just drink one beer. And I honestly believe that. So, Your Honor, we're just asking that you give my client that you give my client a chance. She showed you that she could go without drinking. I believe that violation. When was that violation, Your Honor? November or December 13th?
December 17th
December 17th.
into the 18th.
But if you notice the alcohol level was dropping when it went into the 18th. So it went to 0.04 and it went lower. It went lower and lower each time. So it's not like she was continuing drinking.
Which cuts against the fact of thinking that it's a chemical. Because a chemical wouldn't happen.
I'm not.
It would either remain or it would dissipate faster than the body would be absorbing any alcohol.
And that's why she didn't say she knew it was a chemical. She said that could be a possibility. But one thing she said, I know I wasn't drinking. I know I wasn't drinking. And for the fact of the matter, everything surrounding this situation, I believe she wasn't drinking. Now, even if we were to take that not to be true, what she said to me, I do believe we have a lot of mitigating circumstances to allow my client to stand out of jail. But I'm standing in front of you today that's saying that I really believe my client when she said she wasn't drinking. I seen the video of when she drinks. I heard the discussion. I heard the discussion that the witnesses had with the police that talks about when she drinks and how much she drinks that she just can't stop. So a 0.04, I can't see my client taking a sip of anything and stopping. I can't.
Response from the people.
I would leave it up to your discretion, these sorts of things as I always do. Like 0.04 to me is nothing.
Right. How long has she been on the tether?
For about 2 months, maybe 2 months.
Pardon?
Yes, I've been on it like a month, 2 months.
And as I stated earlier, Yana, she's the one that was taking the breathalyzer and came in here and asked to be on the tether instead of the breathalyzer to ensure that she doesn't.
Here's what I'm gonna do. You want this adjourned, right?
The bond violation. We were gonna say.
Today's docket shows how justice often unfolds quietly, not through dramatic verdict, but through negotiations, warnings, and carefully structured second chances. We saw plea agreements finalized, bond conditions reinforced, and judges making it clear that patience has limits. These rulings highlight the real power of compliance, credibility, and timing in criminal cases. If you found this courtroom session as revealing as we did, hit that like button, share your thoughts in the comments, and subscribe for more in-depth, no-nonsense courtroom breakdowns you won't see anywhere else.
Go ahead, what?
We'd like it dismissed, but if we can adjourn it, Your Honor, then yes, please. We would like it adjourned, but I do know my client is ready to proceed with the plea, but if you're not at that point, then
I'm not at that point yet. I mean, I'm not saying that I won't, but here's what I'm gonna do. I'm gonna adjourn the probable cause and the bond violation. I'm gonna adjourn it out to February 12th, 2026, 9 a.m. And I'm just gonna say it this way. What I really of right should do is I should put you in today. I'm not gonna do that. Mr. Bird has convinced me not to do it. That is something that is against my normal practice, but I'm not gonna do it. Well, don't thank me yet. Because normally you might spend a week, 10 days, get your help, do whatever. But now we're gonna make a deal. I'm gonna adjourn this out to the 12th of February. We have any event whatsoever, I'm not listening to any of that. I'm not listening that it might be a chemical. I'm not listening that something went wrong. I'm not listening to anything. You're just gonna go in and you're gonna do 60 days.